We've got a very interesting case to go over here today. And I want to explain to we the people that this is precisely the type of case that we seek out to show we the people. This type of case where our officers of the court have manipulated our justice system. Manipulated our justice system in order to procure a conviction. They didn't go through the proper channels. They didn't follow the Constitution of the United States. They didn't follow the Constitution of Georgia. They manipulated the laws. They manipulated the facts. They just sent somebody to prison because they decided that's what they wanted to do. This case truly disturbs me. Now, I've got all the facts. I'm going to explain the case to you. Then you're going to read the facts because I'm going to post them on the internet. Now, when we the people put a judge on the bench, we entrust that judge to protect our judicial system. Because our judicial system, other than religion, our judicial system is the only fabric that holds our society together. Our religion and our judicial system. So when we put a judge on the bench, we trust that man to hold that fabric together. That's what we entrust him to do. That's why he's got the stringent canons of ethics and specific rules of conduct and specific procedural court rules to follow. And for one of those judges to thumb his nose at we the people is one of the worst atrocities there is. It's worse than anything that comes before him to judge. Now, to get on with this case. This case is about a young man named Earl Marcellus Windhom. I've gotten to know him rather well. He and I went over this case together. He's convicted of armed robbery. He had a co-defendant. Guilt or innocence in this situation is irrelevant in this case. This man's got a right to go through the judicial process. If he is guilty, the state is required to find him guilty pursuant to the rules. If he has a defense, he has the right to put up that defense. None of these things happened in this case. Here we go. Mr. Windham's co-defendant, his name was Christopher Bradford. Okay? Mr. Windham got a public defender appointed to him. Mr. Braddock got a public defender appointed to him. Well, Mr. Braddock's public defender started looking at this fella and listening to him, and he realized something wasn't quite right. Something just didn't sit right. So he filed a motion and requested that the judge have a psychological evaluation conducted on Mr. Braddock. The judge granted the motion, and a psychological evaluation was granted, in fact. And we have got the psychological evaluation right here. We'll be putting it up. I got it right here. Okay? The psychological evaluation revealed that Mr. Braddock was incompetent to stand trial. He's mentally retarded. Clinically, mentally retarded. That's what the report says. He does not understand the adversarial system. He does not understand the difference between a guilty plea and a not guilty plea. He is incompetent to stand trial. Well, obviously, the prosecutor realized that Mr. Braddock was the weak link in this case. And now that weak link has been removed, and he's not going to be able to get an easy conviction, and he don't know what he's going to do. And he's trying to decide what he's going to do in the alternative, and here's what he does. The prosecutor in this case told Mr. Graddick he'd give him probation in exchange for his testimony against Mr. Windhom. So this man's not competent to stand trial. His testimony's no good if he stands trial, but his testimony's good enough to send Mr. Windhom to prison for many a year. It's the most ridiculous thing I've ever heard. It's the most awful thing I've ever heard. We don't need to debate it, me and we the people. We understand it on its face that it just don't work. It's ridiculous. It's a slap in our face. It shreds the fabric of our judicial system. How dare this judge use a mentally retard to testify against this man as the sole evidence? There's no DNA. There's no fingerprints. There's no eyewitness. There's no camera footage. There's only retarded testimony. Nothing else. How dare this judge, Judge David Mincy III down in Peach County, this just goes to show, folks. So now let me explain one more thing. We got 150 some odd counties throughout the state of Georgia. Each of them has their own independent courthouse. Some of these courthouses got multiple courtrooms all throughout the massive building. They don't tell you how many courtrooms they got in there. And the horrifying thing is that they cranked up every morning, Monday through Friday. And there's nobody in there but that judge, that prosecutor, and one defense attorney. The criminal defendant, he might have a mama in there, he might have a wife in there, a family member, but he's in there alone. It's just them and him. These judges and these prosecutors have virtually got the leeway to do whatever they want to do. And do what they want to do, they will. Do you believe me? And we're going to demonstrate that right here. This just goes to show that they can bring you into a courtroom, prop you up in front of the judge, and go down the street and get some retard and give him a ham sandwich to testify against you, and you go on down the road to a South Georgia prison. Now, the first thing they're going to say is, no, that's not so. We got a court reporter in there who makes a record. Oh, sure they do. They write everything down. They do it, and then they give that record. They give it over here to the clerk of court. The clerk of court takes it over here and files it right here, and it's gone. Who's going to go in there and check it out? Who's going to go in there and watchdog them? Who's going to go over this case and make sure everything was done in accordance with the procedural rules and the canons of ethics and the statutory requirements that are necessary to get required to get a valid conviction, etc.? Who's going to do that? Well, I'll tell you one thing. Georgia Court News has got this one, and we're going to show it. And here we go. All right. Now, when I met Mr. Windhom, we went over this case, and we decided what we would do, since there was no camera footage, no fingerprints, no DNA evidence, no other witnesses, only this retarded fellow, this fellow who's not competent, can't take care of himself, can't testify, don't know the difference between guilty and not guilty. He's the only one that testified. Well, that's not a conviction. That's not that won't hold up in court. It only hold up when nobody knows about it. So we decided to let some people know about it. We filed this plea of nullity record, and what this plea of nullity record says is there was no competent witness, the solitary witness that testified, and the only evidence against Mr. Windhom was not competent because the witness was not competent. And we attached this diagnosis to the back of the plea of nullity record here. And we mailed it in. Now, a plea of nullity record, when you file it and say that you don't have any competent evidence against me to uphold this conviction, the state then has to say, well, yes, we do, and they got to prove it. Now, when you got a plea of nullity record, there's no witnesses to be brought in. You can't bring in no witnesses. You can't admit any new evidence into the record. It's a trial of the record only. We're saying you don't have a competent witness contained in this record to uphold this conviction. You're saying you do. Show us. If you can show us you've got a competent witness, Mr. Windham's got to stay down here in this South Georgia prison. If you can't show us you've got a competent witness to uphold this conviction, you got to let Mr. Windham go. So they read this plea of nullity record, and it's thorough. It covers everything, and we'll read it after a while, and you'll be able to read it on the Georgia Court News website. I can just imagine that prosecutor and that judge getting this plea of nullity record down there in Peach County. They read this thing and they say, whoa, Lord, what? Good gracious. How did this fella figure out how to do this? We cannot let this man have a hearing on this plea of nullity record. We cannot rule on this plea of nullity record, because if we create a record with this document, we're going to have to let this man go. We can't do that, because then we will have admitted doing something wrong. Well, what we're going to do, we got to kill this somehow or another. That's exactly what they did. I'm going to show you how they did it. Now, when Mr. Windham, when he filed this plea of nullity record, this is an important part of it right here. I hate to have to get into this part of it, but nevertheless we do. Filed an application for the writ of habeas corpus ad testificandum. Now, a writ of habeas corpus ad testificandum, it is a procedure. Best explanation of it's right here. Right here, the Supreme Court of Georgia wrote, he also filed an application for the writ of habeas corpus ad testificandum seeking to be brought to court for a hearing on the nullity plea. That's what this procedure is for. Application for a writ of habeas corpus ad testificandum. It's under OCGA 241362, Title 24, and it's an application for the writ of habeas corpus ad testificandum seeking to be brought to court for the hearing on this plea of nullity record. Now, habeas corpus ad testificandum is not to be confused with a general habeas corpus petition. A general habeas corpus petition is under a completely different title. It's under Title 9, 1445. And it's used to attack the constitutional validity of your conviction. You got to show a constitutional error, that your constitutional rights were violated somehow in your conviction. This is altogether different. It's in Title 24, and it's simply a method to get yourself taken to court for whatever procedure you got before the court. That's all it is. Okay. Now, I want to tell you, I got this buddy. He's a roofing contractor. He loves to talk to me about the law and pose different scenarios and get my input on it. And I'm going to tell you, the fella just does not get the law. He just can't get it. He tries and he tries. He always got some kind of twisted take on it. He just does not get it. It just goes to show that generally roofing contractors just do not know or understand the law. Now, I'm a swimming pool contractor. I know and understand the law. Swimming pool contractors, we understand the law. All right. Now, the reason I bring that to your attention is I'm relatively sure that my roofing contractor would understand this. The difference between a habeas corpus ad testificandum and a general habeas corpus. And I say that to explain that when Judge David L. Mincy III, I wonder what the first two were like. Judge David L. Mincy III, he writes this order. He don't want this boy coming to court with this plea of nullity record, because he sees that he's going to have to let this boy go. It's cut and dried. This plea of nullity record frees Mr. Windham. It frees him. Judge Mincy writes this order. Order dismissing defendant's plea of nullity record and petition for a writ of habeas corpus ad testificandum. don't even hold a hearing on it. Don't even bring the boy down there. Pending before this court is defendant's plea of nullity of record and application for a writ of habeas corpus ad testificandum. The court will first address the application for a writ of habeas corpus ad testificandum. In the next paragraph, he goes on to say, under OCGA 91445, service of a petition for habeas corpus shall be made upon the person having custody of the petitioner. He goes on to describe how Mr. Windhom failed to comply with OCGA 91445, a habeas corpus petition. Well, we didn't file a habeas corpus petition under OCGA 91445. We filed a habeas corpus ad testificandum under OCGA 241368. And he knows that. He knows that. But see, he's in a courtroom down there by himself. There ain't nobody else down there, and what he's got to do, see, he's writing this order, and he's going to send it way down in Dodge County, South Georgia, where this boy is in prison at. Ain't nobody going to see it. Ain't nobody going to see it. And he's just going to... I want to tell you, you cannot imagine how frustrating it is. You got the evidence to show that you should not be in prison. You got it laying right here under your nose, and you try to get it into the court system. And you get excited about you're going to be able to get this resolved, and the judge writes something like this. And the judge knows that it usually frustrates the average man to the degree where he just throws his arms up in the air and says, I give up. It's not going to happen here, Judge Missy. So he goes on and he writes an order about a habeas corpus and why he's going to dismiss this habeas corpus. But now I'm going to prove to you in this order that the judge is just merely thumbing his nose at we the people, and he's just reaching across and just might as well be slapping us in the face, we the people. Because here's what he says on the next page. He says, in addition, an issuance of a writ of habeas corpus ad testificandum is predicated upon a prisoner showing that the ends of justice require his presence. He just stated that he knows a habeas corpus ad testificandum is a procedure to ensure his presence before the court. He just said, and the issuance of a writ of habeas corpus ad testificandum is predicated upon a prisoner showing that the ends of justice require his presence. So he knows that it's to require his presence for this plea of nullity of record. But he writes on the whole front page that it's something else. See how he's thumbing his nose at us? We got more sense than that. And he goes on to show, he goes on to say, to demonstrate need, the prisoner must show what he expects to prove and how that proof bears on the case. Here, the defendant has failed to make a showing of what he expects to prove. As such, he has demonstrated no need, and he dismisses the whole darn thing. Now, I'm going to show you that Mr. Windhom demonstrated in this motion what he expects to prove and how that proof bears on the case. Here's what he said. He describes what the nullity of record is on the first page under number 1 and number 2. Number 2, he says that the conviction against the defendant, Earl M. Windhom, rests on the testimony of a single witness, Christopher Allen Grady. And number 3, he says that per the order of the trial court, the Georgia Department of Behavioral Health and Developmental Disabilities found that the principal witness, Christopher Allen Grady, to be mentally incompetent. He expects to show that proof and how that proof bears on the case. All right, number 4, that pursuant to the court-ordered competency evaluation, Christopher Allen Grady suffered from mental retardation, post-traumatic stress disorder, and does not know the difference between pleas of guilty and not guilty, and does not understand the adversarial nature of the court system. That's something that Mr. Windhom expects to prove and show how that proof bears upon the case, and he's explaining that to you, Your Honor, right here. How'd you miss that, Judge Mincy? And number 5, he says that because the state's solitary and principal witness is incompetent, that there is no corpus delicti contained in the record, and before the state may obtain a conviction, it must prove the corpus delicti beyond a reasonable doubt. And he cites Risper v. State, 193 Georgia 157, and it was the year 1941. And then he goes on to say that corpus delicti, meaning the body of the crime, requires that the state prove that the crime charged has been committed by someone. And he cites Reed versus State, 201, Georgia Supreme Court, 789. And that case was decided in 1947. And what he's showing is what he intends to prove and how that proof bears upon the case. Judge Mincy, how did you miss that, sir? It's right here under number 5. But you ruled that in addition, an issuance of the writ of habeas corpus ad testificandum is predicated upon a prisoner showing that the ends of justice require his presence. To demonstrate need, the prisoner must show what he expects to prove and how that proof bears on the case. Here, the defendant has failed to make a showing of what he expects to prove. As such, he has demonstrated no need. For all of the reasons listed above, the defendant's application for a writ of habeas corpus ad testificandum is hereby dismissed. Now, he go on to say, lastly, the defendant predicates his plea of nullity of record on his anticipated grant of an application for a writ of habeas corpus ad testificandum. Since his application for a writ of habeas corpus ad testificandum is dismissed, his plea of nullity of record is also dismissed for the reasons listed above. Boy, you didn't want that fella coming down to that courtroom, did you, Judge Mincy? Judge Mincy, you know what I think, Your Honor? I think we need to have you tested. I think we need to send you to the Georgia Department of Behavioral Health and Developmental Disabilities. My roofing contractor buddy got better sense than this. That's not what it is, though, Judge Mincy. You ain't fooling us. We know exactly what it is. All right, now, we're going to move along here. When Judge Mincy thumbed his nose in our face, we the people, and when he gave these false statements of material fact, and when he gave these false statements of material law, and when he dismissed this man's right to come down into the court and have his conviction reviewed, have the evidence reviewed pursuant to this plea of nullity of record, well, Mr. Windhom appealed the case. And when the case went up to the Court of Appeals, well, you would think that a whole panel of appellate judges would have caught that Judge Mincy was ruling under the wrong statute and twisting the things around and making false statements of material fact and false statements of material law, but they just followed his lead. They just went right along with it. And what the Court of Appeals did, they sent it up to the Supreme Court. Said they didn't have jurisdiction, that the Supreme Court's the only one that had jurisdiction for habeas corpus cases. Well, the Supreme Court ruled right on it. The Supreme Court, just going to read the first paragraph of what they ruled. Appellant was convicted of the armed robbery Windhom versus State, and recently filed in the court of conviction a plea of nullity of record in which he essentially alleged his conviction was void because the principal witness against him was incompetent to testify against him. He also filed an application for the writ of habeas corpus ad testificandum, seeking to be brought to court for a hearing on the nullity of plea. See OCGA 24-1362. See, Supreme Court got it. They ruled right, but now they wasn't going to get into. They didn't want to get into this hornet's nest here. Supreme Court's good about tap dancing out of that, but they ruled the right way. They sent it back down to the appeals court. Now, what I would have liked to have seen them do, and they got the power to do it, I wish they had sent a complaint to the Judicial Qualifications Commission on this Judge David L. Mincy. And I wish they had filed a complaint at the bar against this prosecutor. They've done it in the past. They do it when they need to. I wish they'd done it this time, but they didn't do it. But we got to get this judge off the bench. We can't have a judge going around thwarting our judicial system like this. He's just shredding the fabric of our judicial system. He's just slapping we the people in the face. Judge Missy, my name is Richard Bradford. This is Georgia Court News, and I'm going to tell you what we're going to do, sir. What we're going to do our best to get Mr. Windhom some relief. We're going to do it whether it's with you or whether it's without you. We don't need you, Judge. You've demonstrated what we can expect from you. And what we're going to do, we're going to file a judicial qualifications complaint against you, sir. We've got all this evidence. There ain't no way you can wrangle your way out of it because Georgia Court News has got it right here. I'm going to put it up on the Georgia Court News website, and I'm going to tell you what I'm going to do, sir. I'm going to spend every day, I'm going to be sending it out somewhere else. I'm going to publicize your actions in this case just as far and as efficiently as I can publicize it. I'm going to make sure that everybody knows the character of this judge who we the people have entrusted to protect the moral fabric of our justice system and how you have treated it. This is Georgia Court News, and this is the end of this podcast.